Unit 5.5, Notice and Settlement Procedures. Our learning objective. When you've finished reading this topic, you will be able to describe the 4 different settlement procedures that are available to a broker who has received conflicting demands or has good faith doubt as to which party should get funds that are being fought over. Notice of settlement procedures. When a broker assumes the responsibility of escrow agent, they keep the funds in their own escrow account. The deposit belongs to and is under control of the depositor or the buyer until the seller accepts it. It never belongs to the broker until after the closing and then whatever you get paid for. So the broker must not deliver the deposit to any other party until the transaction is closed. Money goes in the escrow account, there it stays until it goes to the closing. Now the funds never belong to the broker. The broker just holds them in trust as a third party for the buyer. Now the buyer has control of the deposits until the seller accepts the offer, in which case both buyer and seller have limited control until the closing or any other appropriate situation allows the money to be released in agreement between both parties. Chapter 475 provides a dispute resolution process when there are conflicting demands between the parties or a broker has good faith doubt as to who gets the money. Conflicting demands occur when the buyer and seller make demands regarding the disbursing of the money that are inconsistent and cannot be resolved. In other words, the buyer says they should get it, the seller says they should get it. Now, if a broker who maintains an escrow account receives conflicting demands on the escrowed property, the broker must notify FREC in writing within 15 business days of getting those demands. That is important to remember. Now, the broker must institute one of the 4 settlement procedures within 30 days from the time that they received the conflicting demands or they had good faith doubt. Now that's important. 15 days from day that they started fighting over it. 30 days also counts from the day they started fighting over it. All right, so here's an example. If the broker waits the full 15 days to report, then they have 15 days left out of that 30 to implement one of the settlement procedures. Now, if they don't wait the full 15 days to report, they do it early by 5 days, in other words, within 10 days of getting the dispute, then that means they have 20 days left to implement something to help settle the dispute. So both the 15 and 30 start from the same day. Now, once you let FREC know within 15 days the settlement procedures that you can choose from to solve these conflicting demands are as follows. And it's another acronym, this time MAIL. We have M for mediation, A for arbitration, L for litigation, or E for escrow disbursement order. Mediation. If all parties give written consent, the dispute may be mediated. Now, mediation is an informal, non-adversarial process intended to reach a negotiated settlement. An independent third party works with the disputing parties to help them resolve their differences. If they reach an agreement, then they form a written agreement which is enforceable in a court of law. Now, if they cannot sit down at the table and peacefully come to an agreement within 90 days, then you have to move on to one of the other settlement procedures. Another possible settlement procedure is arbitration. This is a process whereby you get the prior written consent of both the buyer and the seller, submit the matter to a third party, and have that third party designate who should get the money. This is a binding judgment in favor of one side or the other because the parties agreed in advance to abide by the final decision in writing. Now, this won't work if they decide that they don't trust this arbiter to make the decision for them. So, If they will not mediate it, they refused to arbitrate it, we move on to the next, which is litigation in the courts. Litigation. If the disputing parties cannot agree, then they just go duke it out in court. Now, litigation involves either of the two following procedures. Number one is inter pleader. If the broker does not have any financial claim to the money, then you just hand them over to the court registry, slowly back away, and excuse yourself from the case and let them solve it in court. Or we can go the route for declaratory judgment. That is when the broker believes that they are entitled to a portion of the funds. In this court procedure, the judge will declare each party's rights to the disputed funds. Why, might you ask? Does the broker think they get anything out of it? Well, advertising costs. Let's say you put your own money together, you bought materials, created signs, and so on and so forth. You've got money vested in this. So, if, for instance, the seller, let's say your listing, decides to fall through, and they decide they don't want to sell at all, well, the broker could at least try to get their money back for all the money that they put into trying to get this sell. And then finally, as a different route that you could go, you could attempt an escrow disbursement order. Now, this is a determination made by FREC as to who gets the money. Now, FREC will not issue an escrow disbursement order if the funds are held with a title company or an attorney. They will only do this if it's the brokerage escrow account holding the money. An escrow disbursement order procedure is only available if the funds are held in the brokerage. Okay, I already said that. If informed in writing that FREC will not issue an EDO, then the broker has to use one of the other settlement procedures. In such an instance, the broker must notify FREC which settlement procedure that they are going to choose. FREC rules require a broker to notify them within 10 business days if the dispute gets settled first or if the matter goes to court before they issue an EDO. Which I don't blame FREC. I wouldn't want to go to a monthly meeting, sit down, spend 15-30 minutes discussing who should get the money, only to find out, oh, it was solved a week ago. I would be upset too. Now, if the real estate licensee promptly employs one of the 4 settlement procedures and abides by the resulting order or judgment, and this is good news, a complaint may not be filed against the licensee for failure to account for and deliver escrowed property. In other words, the broker is immune from disciplinary action. So as long as you follow the rules and you give the money to whoever is supposed to get it following the procedure, the losing party can't be a sore loser and try to sue you in court because they didn't win.